So we're on the record. Good morning, everyone. My name is
morning,
Judge
Judge.
Backman, and we'll get started as soon as we can find your case.
Thank you.
Thank you so much. Okay. We have Benjamin Soto.
Yes, Judge, good morning. Colette Drimmer on behalf of Mr. Soto. Your Honor, Mr. Soto was charged with a burglary and criminal mischief. I'm arguing PC as far as the burglary. It stated he did enter the aquatic center with the intent to swim in the pool, and the pool was closed at the time. But it said while he was in the pool swimming, he noticed one of the foam markers was damaged. It doesn't say he damaged it. He didn't remember when the lane was damaged. Then he heard a loud noise and he saw that there was a gray cart pushed into the pool. He did not push it. And then he placed an orange cone on top of it. So, Judge, I'd argue this is a trespass, not a burglary.
Your Honor, Aaron Passy on behalf of the state. He enters into a closed business. He then commits criminal mischief therein. That satisfies the element for the burglary, for committing damage or structure within.
And Judge, it doesn't state that he actually committed the damage. It just stated it was there. The only thing he did was swim and put a cone on top of it, which doesn't amount to even criminal mischief.
Okay, thank you. And what is the state's position?
Backstroke flags were also damaged. The damage to the lane line was $800.
Okay, so what are you suggesting for, assuming I find PC for the burglary?
And Judge, he has absolutely no priors. He has his whole family here in Broward County. He has his mom's a single mom. She's a teacher.
He has no priors. The state's recommendation would be $1,500.
It's what?
$1,500.
Okay. And we're finding probable cause for trespass?
Yes, I'll stipulate obviously to that.
Okay. PC for trespass. And you're saying bond is $1,500? And the criminal mischief, less than $1,000. Bond will be another 100?
I'm sorry?
100?
And Judge, I would argue that too as well. It doesn't say he pushed the golf cart in or that he did any of the damages.
All right, then I'll do no charge on that one.
Thank you, Judge.
Okay, thank you.
So the total amount, Your Honor?
1,500.
1,500, okay.
Thank you. Okay, Gabriela Flores. Pardon? Good morning. Hi, ma'am. You're being held on an out-of-state. Oh, we're gonna reset this for the PM. All right, thank you.
For people.
Does anyone know how to make this not so loud from the main jail that I can't hear what's going on? Is there a way?
Mr. Romero, can you please turn the microphone off in the main jail?
Yeah, and then right there, it's already down, Judge. It's to the right, but it has to come from the jail now.
It should be. They
Okay,
weren't. I don't know.
that's better. It was really loud. Can you hear me? Yes. Okay, good. So I'm calling Olympia Morrison.
Been informed she bonded, Judge?
Okay, thank you. For the record, PC. Sandra Sanchez.
She's here present, Judge, in name?
Okay, good morning, ma'am.
Good morning, ma'am.
You're being held today on a misdemeanor capias. Your judge set for $500, and I find probable cause. Thank you. Marie Brown.
And Judge, in speaking to Sanchez, she's inquiring if the court would consider resolving this case. It's an operating without a valid license. She advises she doesn't have the $500 and she wishes to resolve the case at this time.
I don't choose in my discretion to change another judge's set bond. So no, sorry. Marie Brown.
Yes, ma'am.
Good morning.
Good morning, how are you?
I'm good, ma'am. You're being charged on 2 capias counts, $500 bond each. I find probable cause, and your next status is going to be set. In what? I can't read this writing, but it'll be set. Does anyone know? Thanks. Thank you. Debbie Maldonado?
North Broward, Your Honor.
She's here.
Morning. Ma'am, you're being charged here with 4 separate KPIs or KPI, 4 different KPI on 4 different charges. And bond is set on the first one at 100, the second at 500, the third at 500, and the fourth at 100. And I find probable cause, and your next hearing date is on July 17th at 1:30. Okay, thank you. Natalia Johnson?
Ms. Johnson's here present, Judge, at Maine.
Good morning.
Good morning.
Ma'am, you're being charged with 1 count of alleged trespassing upon order to leave by the owner, and that is a bond of $2,500 and a warrant VOP misdemeanor for $1,000 set by the North Magistrate Judge. I find probable cause. Yes,
Just for clarification, on count 1, you said $25 is the bond on count 1 and $1,000 is the bond on count 2, correct?
correct.
Okay. Judge, I have, in speaking with Johnson, she's inquiring if the court would consider resolving both counts today.
No,
Someone else. It's actually
thank you.
violation of pretrial. Let me see. VOP will just say VOP.
Virginia Donnelly?
North Broward, Your Honor.
Good morning. Ma'am, you have 2 KPSs holding you each for $250. I find probable cause. Thank you. Nikki Myers?
Medical reset, I believe.
Judge, I think it's a medical.
Just leave a reset folder right here.
Thank you. Kathy Ann Akins? Good morning.
I mean, medical reset, just
Ma'am, you're being held on $25 bond for alleged trespassing. I do find probable cause.
Judge, based on my conversation with Miss Akins, she would like to resolve this case if the court is so inclined. It's a trespass from in front of a racetrack.
Just have them check out a few priors, if any, and then I'll try and work with you, ma'am.
Thank you, Your Honor.
she does. Your Honor, Eric Winter on behalf of the state. This is on Ms. Akins. 2015 trespass, 2013 battery on child, 2007 grand theft, 2007 grand theft, 2005 possession of cocaine, marijuana, resisting without violence, 98 under the name Kathy Butler, DUI, traffic fleeing and eluding, she violated probation, resisting without violence, 02, possession of marijuana, 01, possession of marijuana felony amount, resisting without violence, 99, delivery of cocaine, 98, 6, end of record, Judge.
Judge, and again, it's a trespass in front of a racetrack. She's indicated that she'd like to resolve this case. From what she's told me, she's lived here in South Florida for the last 30 years. She's unfortunately not working right now, Judge. I see that the standard bond is $25. She's told me that she'd be unable to post that bond. The allegations are that she was in front of a gas station. She was given a hot dog, and the management asked her to leave, and she allegedly refused to leave. She's indicated that she'd like to resolve it. She's in custody right now. Would the court be inclined to make an offer to her?
It's adjudication. I'll take judicial notice of time served and any and all costs associated with this charge.
Ms. Akins, did you hear what the judge said to you?
And then no return, Your Honor?
And no return to the place in question.
How does that sound to you, ma'am?
You have 4 months to pay whatever the court costs are, and you get fingerprinted, and it's an adjudication. So no contest? All right, thank you.
Thank you,
Have a good
Judge.
day.
If someone has such a
4,
low BCCM,
Anita DeGrove.
either they have no
North Broward.
there may
Good
be
morning.
morning. Safe, just like the lines on that.
Okay. Your bond's been posted. Yes, you're welcome. And I find PC, of course. Josephine Slade. Good morning. Okay, you're being charged with alleged offer of committing a lewd act. I do find probable cause, and your bond is set at $100.
Judge, based on my conversations with Ms. Slade, she's indicated to me that she too would like to resolve. We have a couple of these cases, I think, all involving the same officer this morning. She's allegedly, she spoke to the officer and solicited some money in exchange for an agreement to perform an act of prostitution. Judge, she is seeking to resolve this case. From what she's told me, she's lived in South Florida since 2004. She's presently looking for work. She's living with her mom and her dad. Only her dad is working. Her dad works for Greyhound. She's lived here in Fort Lauderdale since she was 23 years old. In addition to her parents, she also has a grandmother that's in Dania Beach. She's indicated to me that should the court not be inclined to resolve this case today, that she would be unable to afford the $100 bond. Judge, my first request is if the court would be inclined to resolve this matter today.
I'll listen, hear what the state has to say.
Your Honor, she has 3 arrests since April, one of them for the same charge.
Actually, both of them.
And she also has a possession, she has 3 pending cases, and she has a pending violation of probation on a 3rd-degree felony, dating back from 2014. And then she has a few priors before then for criminal traffic, and she's on pretrial for prostitution.
So would the state suggest that I revoke pretrial?
Well, that would be a pretrial. Do you want the case number?
176204.
Oh, no, it's on
The other one.
It's actually on a different case.
All right, so we
Ends
can
in
recall
385,
this, but at this time, it doesn't sound prudent to resolve at this time. So, thank you. Melinda Vaughn. Good morning. Ma'am, you're being held on a no bond violation, alleged violation of probation felony. The court finds probable cause, and your next VLP is on 7/11/17. Thank you. Jamie Widner Fulton.
Yes, ma'am.
Good morning. You're being held on 3 violation of probation, no bond holds. Court finds probable cause. Your next date is July 11th at 8:30. Thank you.
Thank you.
Meg McDonough. Good morning.
Good morning.
Ma'am, you're being held today on a violation allegedly of probation felony. There's a no bond hold. The court finds probable cause. Thank you.
Thank you.
Kimberly Hudson.
I've been advised Ms. Hudson bonded, Judge.
Okay, thank you. Probable cause is found. Don Dwyer.
Main jail, Your Honor?
Good morning.
She's here present, Judge, at Maine.
Ma'am, you're being held today on a no bond hold for an alleged violation of probation felony. I do find probable cause, and your next hearing is on July 11th at 8:30 a.m. Okay, thank you. Nicola Delgado.
Yes.
North Broward.
I'm a little hard of hearing my left ear, sorry.
Good morning.
Good morning.
You're being held, ma'am, or being charged with 1 count of neglecting a child without great bodily harm, a 2nd count of DUI, alcohol or drugs, first offense, 3rd, DUI balance greater than .15 and accompanied by a person who's less than 18 years of age, and 4, DUI balance .15, accompanied by a person less than 18 years of age. Count 1, we have to set a bond. Counts 2, the bond is $500. 3, $1,000. 4, $1,000. And the court finds probable cause. However, we need to set the neglect.
Judge, actually, I didn't get the opportunity to speak to Ms. Delgado. If I could maybe put her on a brief recall just so I can call up there and learn some facts about her that I could communicate to the court.
Certainly, I'll just put it right here, okay?
Thank you, Judge. Ms. Delgado, don't go too far, okay?
Okay.
Keone Williams?
Oh, my God.
I have the reset here. Good morning. Ma'am, you're being charged with alleged engagement of a lewd act. One bond is set at $300, and a second count of drug paraphernalia possession, and an out-of-county hold felony, no bond. So your bond for count 1 is $300, I find probable cause, and for count 3, there is a no bond hold.
Judge, as to count 1, I did speak to Ms. Williams, and she's indicated she would like to resolve this. Of course, we see the nature of the allegations. Regardless of what we do, she's got the out-of-county hold that I know she wants to deal with. Judge, she's just seeking a resolution to count 1, and I suppose it would be count 2 as well, just so that way she can get on her way to deal with the more serious charges out of county.
Can the court inquire if she's on probation for count 3?
I can't hear you.
Will the court inquire if she's on probation for count 3?
Are you on probation for the out-of-county hold, count 3?
No.
Your Honor, the state would make an offer of an adjudication as well as a HIV test on count 1 and,
Withhold court costs on count
and a withhold court cost on count 2.
But, Your Honor,
Understand that? Yes.
but the only thing we'd ask is if the court could advise Ms. Williams that we have no way of knowing what impact this could have on count 3. It could have there could be negative consequences on her out-of-county case based on this plea.
But you understand that, ma'am, that whatever you do today in Broward could have negative impact on the Leon County case. Do you still want to? Do you still?
Negative impact? What do you mean by that?
Well, maybe you should speak with a public defender, because it would be safer for you before you make any resolutions that you talk to a lawyer, okay? Thank you. So I'm finding probable cause, and we'll see what the lawyer says to you. Thank you. Dynell Tillman. Okay, thank you. Good morning.
Good morning.
Ma'am, you're being charged with alleged offer to commit a lewd act. Bond is set at $1,000, and I do find probable cause.
Judge, respectfully, in speaking with Ms. Tillman, she's been residing in our community her whole life. She is 47 years old. At this point, unfortunately, she's landed on some rough financial times. She's looking for work. She hasn't had any success. She lives in Fort Lauderdale with her boyfriend. Her boyfriend does odd jobs. They just finished paying the rent. They've been living at the same apartment now for about 4 years. The rent is $800. So the boyfriend, with the wages he's managed to save up, has just paid the rent. Unfortunately, right now they're financially strapped and no more money available for bond. What we respectfully be asking you, Judge, considering she's been here her whole life and she has a valid address, if pretrial can verify where she lives, would you consider pretrial release? And that's what that's what we ask.
Pretrial said they were unable to validate her address, but they will try. So we'll do pretrial pending, and bond is set at 1,000 if not, for whatever reason, okay?
We appreciate that. Thank you very
Thank
much,
you.
Judge.
Trinicia McKinney.
I've been informed Ms. McKinney bonded, Judge.
Okay, thank you, and probable cause is found. Kimberly Bolton.
North Broward.
Ms. Bolton? Good morning. Good morning, Ms. Bolton, good morning.
That's not Ms. Bolton.
I'm sorry, Kimberly Bolton looks to be in the main jail intake for my docket.
So we're just resetting
Judge,
it?
I've been informed as far as, I believe she was transported to North Broward, so she's either en route or she's already arrived at North Broward, so it's one of the other.
So we'll reset it for this afternoon.
Unless, I mean, North Broward, do you have her while we have you up? North Broward, do you have Kimberly Bolton? I think we have to reset,
So we'll
Judge.
reset it for the afternoon.
And Your
Thank
Honor, I'm
you.
ready for Miss Delgado on recall in North Broward whenever the court is ready.
Is this Miss Delgado in front of me? No, this is Ms. Good. This is Caitlin Good, so you're here, good morning, let's take care of what you're here for. So I find probable cause for the count of possession of cocaine, bond is $1,000. And for count 2 paraphernalia, there's no charge, so probable cause on both. Okay, thank you.
Your Honor, would you like to see Ms. Delgado now?
Sure.
Ms. Delgado?
Thank you, Judge, for giving me the opportunity to speak to her. I know that you had set, let's just make sure she's here.
She's coming right now, Your Honor.
There she is. Judge, I just had the opportunity to speak with Miss Delgado. Of course, she's entitled to a bond on count 1. From what she's told me, she's lived here with her family, including husband and 2 children, in Fort Lauderdale for the last 2.5 years. She moved here with her family from California. Unfortunately, she recently lost her job. She was working, running the front office of some sort of boat or nautical company. Her husband is also working. He works as a salesman on commission. And what she's told me is that the family, in light of her recently losing her job and her husband being on commission, the family unfortunately is dealing with some financial troubles, Judge. Obviously, she's entitled to a bond on count 1. We're asking that the bond be as low as possible since she has the additional bonds on counts 2, 3, and 4.
Your Honor, Ms. Delgado has a 2008 DUI arrest with no disposition out of California, and the state would be requesting a $3,500 bond and supervised contact with the children.
Based on the seriousness of the accident.
Judge, I'm sorry. The only thing that I would say, if the court is inclined to grant the state's request as to supervise visits with the child, or supervised visitation with the children, that would be under the care of any other adult, including her husband that she resides with. Is that?
That's correct.
Thank you.
All right, so bond is set at $3,500 on count 1, and supervised visitation for the 2 children. Thank you.
It's with an additional condition that that no alcohol or intoxicants.
You understand that? No alcohol, no intoxicants. Thank you.
Thank you.
John Sherman.
Conti, Your Honor?
Good morning, sir. Good morning. Sir, you're being charged with a no bond hold on an alleged violation of probation, and your next court date is July 12th at 9 a.m. Yes. Instead of the no bond? It should be $5,000. Okay. So bond was set by your judge at $5,000. Your next hearing, thank you, is on July 12th at 9 a.m. Thank you. Thank you. Javante Brun.
Judge, Mr. Brun is here present at name. This is Amina Forney. The public defender's office doesn't represent him. I know he was here yesterday, and I believe he had another unit form in which you resolved. I just wanted to give you, as a friend of the court, that information.
Okay, thank you. So you want to resolve this too?
Yes, ma'am.
You have a place to live?
No, ma'am.
So can you volunteer at a shelter? Can you do something and not come back?
Yes, ma'am.
All right. So it's an adjudication. The court costs are either $208, 4 months to pay, or you can do 16 hours of volunteer work at any nonprofit organization, plus $50 in 4 months. Whatever you choose. But if you need more time, just write me a letter, ask for an extension, and find yourself somewhere to live, please.
Yes, ma'am.
Thank you. Pardon? It's $208 are the court costs in Hollywood. So it's either the money in 4 months or 16 hours community service at any nonprofit organization, plus $50. Thank you. Counsel.
Good morning, Judge. How are you?
Good, how are you?
Fine, thank you. Judge Jara McLawrence, I'm here with the City of Fort Lauderdale Municipal Ordinance Defense. Judge, there's Marie Brown. I'm not sure if you've handled that case already or not. It's on page 2 of your docket. She's in the North Broward facility.
Familiar.
It'll be at the top of your docket. Marie Brown is her name. You did it? Okay. Okay, Judge, so I was informed you did it already. There's, on page 12 of the docket, Your Honor, there's Mosley Mangle, and he's over at the main jail.
Mosley Mangle.
Yes.
Someone,
Yes.
Judge, I do not believe he's here right now. On the docket, it seems to indicate says no paperwork. So I'm assuming that's why he wasn't brought.
Lawrence, do you want us to see if we can find it or reset it?
No, he'll be reset, Judge, probably for the afternoon or
Very good.
tomorrow. We did? Judge, I'm going to request that the court appoint my office to represent Mr.
Certainly.
Mosley on the 1986 MO case.
You got it. Thank you.
Yes, Judge. On the next, Judge, on the next page, there's Lamont Green, and he's also in the main jail.
He's approaching, Judge. Green?
I haven't done that yet, have I? And I'm just looking for him. Oh, okay, here we go. Mr. Green, good morning, and this is a capious misdemeanor, bond set at $150.
Yes, Judge, it's an alcoholic beverage offense, Your Honor. I was going to ask if the court would be inclined to resolve this matter so Mr. Green could be finished with this case and be released, Judge. I was going to ask if you would give him a withhold and take judicial notice of time served.
And adjudicate, and whatever court costs, he would have 4 months to pay. I have to impose them.
Is that fine with you, Mr. Green?
Yes.
So you're saying no contest?
Oh, no contest.
All right, thank you, no problem.
My bad, because I just got out Wednesday at another
Okay.
jail.
Take care of yourself.
Okay, thank you.
Thanks for that information, Mr. Green. Judge, on the next page, Judge, there's Christian Ulpiano.
Judge, I've been informed, I believe Mr. Cupiano bonded.
Okay, could someone tell me how you spell Cupiano so I can find it?
It's Ulpiano, U as in umbrella, Lpiano.
Is it after Williams? Anyone know?
Yes.
Here he is. Ulpiano. Bonded, yes?
Yes.
Probable cause.
And that's it, Judge. Thank you.
Okay, thank you, Mr. McLaurin. All right, moving right along. Dante Harris. Dante Harris,
North Broward, Your Honor. I believe that's North Broward, Judge.
good morning.
Hello, ma'am, how are you?
Good, how are you? They're accusing you of alleged trespass, and bond is set at $25.
Judge, I've spoken to Mr. Harris, and he's indicated he'd like to resolve the case this morning if the court would so inclined. It doesn't say from the PC what this location is, the 599 West Atlantic. The only thing that it says is that he was allegedly, quote, harassing customers for money. I can only assume that that means that this is a business of some sort. From what he's told me, Your Honor, he's not working right now. He's living in Pompano Beach. If the court is not inclined to resolve this, he's told me that he would be financially unable to raise simply the $25 needed. Judge, it's a simple trespass. He's asking to resolve. He's in custody right now.
State anything I should know?
Your Honor, this is this gentleman's fourth arrest since May 7th. He has a pending charge for possession of cocaine and trespassing.
The trespass was resolved June 27th.
I apologize. That trespass was resolved June 27th. He then has another trespassing case which was resolved on June 14th,
This one,
and another trespassing charge which was resolved on June 22nd.
So,
was in the
if we
area.
resolve it today, you're just gonna go back.
this was in the area.
Do you have a place to live?
No, I don't have a place to live. I really wasn't harassing anybody. I was just simply panhandling. Harassing is taking it a little too far.
Okay, but you're not allowed to panhandle even if you were, and you really shouldn't be telling me stuff like that. But my question to you is, what happens if I release you, find you guilty, and what are you gonna do with your life?
Well, I have to try to dig myself out of this hole. So,
Can you volunteer at a shelter?
no, I don't want to volunteer at a shelter, man.
At a church?
I wouldn't mind volunteering at a church.
Do you know of any churches nearby in Pompano?
Yes, ma'am.
Okay, so why don't we try that? It'll be an adjudication, meaning you're gonna get fingerprinted and found guilty. No return to the place in question, no more allegedly asking anyone for money. And you can do community service hours plus $50 in 4 months.
Service hours.
Yes,
Panhandling?
I'm not gonna negotiate, but if you wanna take a deal and get out of jail, these are the terms.
Mr. Harris, what she's saying is that there's court costs, and there's certain court costs the court can't waive, and so what she's providing you is an opportunity if you would rather do community service in lieu of paying your court costs, she's giving you that option. I don't believe, and correct me if I'm wrong, that she's mandating the community service. She's just giving you that as an alternative
Right, I'm
in
trying
lieu
to
of
be
paying
nice.
the court costs if you would not like to pay the court costs.
If you can't. All right? 4 months to do one or the other, your choice. Adjudication. Maybe you could find a church you could help out with, and maybe they can help you. Okay? Thank you.
For Judge Lorenzo,
So-
application, that's MI.
So do I get released today?
You're agreeing to say no contest? Then yes.
She will.
Okay, thank you. Nicole,
All right.
have a good day. Nicole Mohammed.
Mohammed is here present, Judge?
That shouldn't even be here.
Good morning.
That's not.
Sir, good morning, sir. You're being held on 2 KPS misdemeanors, bond set at no bond on each one. Court finds probable cause. Thank you. Joseph Carcamo.
Judge, Mr. Carcamo, I've been informed bonded.
Okay, thank you. Probable cause. Durini Jones.
Main jail, Your Honor?
Good morning.
Excuse me, not main jail, North Broward, forgive me.
North Broward, Your Honor.
Good morning.
Good morning, Your Honor, sir.
You're being charged with alleged drug paraphernalia possession and having an expired driver's license.
Judge, I've got a probable cause argument as to count 1.
Let's hear it.
Judge, count 1 is the drug paraphernalia. Drug paraphernalia is a somewhat vague definition, but what I would say is the substance that was recovered from inside of the pipe was not confirmed on the Valtox test to be a narcotic or controlled substance. As a result, Mr. Jones, we're not going to speak about the allegations this morning. As a result, Your Honor, I don't believe that they've met the requirement for the definition of drug paraphernalia as to count 1, because frankly, anything could be drug paraphernalia. There's no indication that that item was used or endeavored to be used to consume drugs or substance.
And that case number is 173046CF10A. Does the state want time to perfect?
Your Honor, we're not, Eric Lynn on behalf of the state, we're not gonna ask for time to perfect. However, the state is concerned, considering the charges he's on pretrial for, leaving the scene of an accident, with injury in DWS, and now apparently there's a driving charge on,
I'm gonna revoke pretrial, and what is the state requesting?
one
Even
moment,
if
Your Honor.
there's no probable cause at this point for the paraphernalia?
yes, we would be asking for a $1,000 bond on count 2.
Okay, so for the second time allegedly operating the motor vehicle, bond is set at $2,000, and there's no probable cause found on count 1. Okay, and pretrial services are revoked. Thank you. Jose Feliciano,
Can't have it.
Feliciano, if you're present, Judge Anani is supposed to judge.
morning.
Morning.
See, this is
Sir,
somebody
so-
who safe's open, you can just check his.
First offense, driving while license suspended with knowledge, bond set at $100, and allegedly failing to register the motor vehicle. No charge.
If the defense could be heard, and speaking of Mr. Feliciano, he's been residing in our community since 1986. He is 44 years old. He's employed, he works in construction. He makes approximately $10 an hour. He lives in Fort Lauderdale in an apartment. He lives there with his 3 children. He's a single father. He has 3 kids, ages 15, 12, and 10. Right now, he does have members of his family that live in our community. His sister's actually right now taking care of his children. Unfortunately, since he's a single father, he provides for the rent, he provides for all the expenses. So right now, he has no sort of income to post bond. He has no money to make, no property. He is a registered voter. Judge, considering this is a nonviolent offense, he has strong ties to the community. He's not a flight risk at all. This isn't a violent incident or anything like that, Judge. Would you consider an ROR on Mr. Feliciano if you have?
He's good.
As long as he doesn't drive. If I gave you time, could you get yourself a license?
Yes, ma'am, I'm working on it right now.
So, we don't know who the judge is, but it looks like you were arrested in Pembroke Pines. So, it sounds like it's me in another capacity. So, today you're saying not guilty. And you're not gonna drive until you get the valid license. I know it's hard in Florida, but if you drive and you get caught, you see what happens. All right, so I'll see you back in my courtroom in 4 months on a Tuesday morning. Okay?
Thank you. Thank you, Judge. Thank you.
Pardon? Yes. Feliciano, 4 months continuance defense? Okay, so there is probable cause.
His
and
case
I'm-
may end up in that central for all we know.
Okay, so probable cause is found, don't drive. Yes. Kevin Puryear,
It's Emma, but we got Scott coming up. Here,
good
don't worry.
morning.
There's Emma. Get ready
For years
for
here present,
Scott
it
case.
is a municipal ordinance case.
Oh,
Hello.
yes, ma'am. I would like to resolve the case today by pleading no contest.
Okay, you have a place to live?
Yeah, but we took those 2 out of order. Scott? That's one of those 2 misdemeanors.
You have a place to live, sir?
No, ma'am, no, ma'am.
So what are you planning to do if you get out?
Just, go back to doing what I was doing, just, homeless in the streets, I have nowhere to live.
And is that your choice? Could you volunteer somewhere so maybe you'd get a foot in the door at help out at a church, something?
I probably try to go to the homeless shelter, St. Lawrence,
All right.
St.
Well,
Lawrence Chapel.
okay.
That's,
so-
located out on Blunt Road.
Sounds like a good idea. All right,
Yes,
so
ma'am.
it's an adjudication. You can volunteer instead of paying money at any nonprofit organization, or you can pay whatever court costs and you get fingerprinted. Okay? No
Okay,
contest?
so
So you're saying you're not fighting this? You wanna go home, go out? Okay.
I'm not planning to.
All right, so no contest. Thank you.
So what it, I'm with,
Izette, Scott,
Mr. Scott is here present, Judge, at Maine.
good morning, sir. Sir, you're being charged with 2 counts of alleged battery, bond being set on each one at $1,000. All, looks like the state wants to be heard.
Thank you, Your Honor. The state would be requesting a bond increase to $2,500 for each count due to the fact that the co-defendant brandished a gun
Thank you.
and try to help him obtain it while they're in this squabble.
Judge, the defense was gonna actually request a bond decrease from the standard bond. He's 18 years old. At this time, he's currently looking for work. He's not employed as of yet. He lives in Coconut Creek with his mother. His mother works for AT&T in customer service, so he's gonna contact his mother to help post his bond. I was gonna ask you, right now it's currently set at $2,000 a bond. I was gonna ask you to see if you could lower it by $500 each count, so that would be a total of $1,000, and that would be something more accessible in order for his mother to post Mr. Scott's monetary bond.
I understand, but as a problem in the probable cause affidavit, brandishing a gun and allegedly pointing it at victims, I'm gonna set the bond at $5,000 for count 1 and for count 2, $5,000.
But again, Your Honor, according to the PC, it was not Mr. Scott who engaged in those activities. He allegedly was present during that criminal activity, but it was not he himself who was in possession of the firearm. He has a co-defendant who's facing those allegations.
What the state's concern was and what's alleged is that at one point while the victims were trying to protect themselves, the gun was on the ground, and it says that Mr. Scott actively assisted his co-defendant in reobtaining the gun. So he did have an active involvement at one point in his co-defendant becoming armed.
Okay, and that's my rationale. Thank you. Have a
And
good
Your Honor,
day.
we'd ask for no victim contact.
And no victim contact. Timothy Odom.
Mr. Odom's here present, Judge?
Okay, good morning. So this looks like trespassing, bond set at $25 and a KPS set at $250.
Judge, in speaking to Mr. Odom, he's asking the court if you would consider resolving his case on count 1 and on count 2. From what I can see, count 2 is in reference to a KPS pedestrian obstructing traffic. I don't know if that's a panhandling, a fancy way of saying panhandling, but Judge, Mr. Odom is requesting if Your Honor would consider resolving both cases for adjudication, time served.
State have a problem with that?
See if there's any issues with offering the plea.
What are you gonna do if you get out?
Sorry. Where are you gonna go if you get out?
I'm like to the VOC and volunteer in Hollywood.
Okay, Broward Outreach. Okay, very
I've made
good.
arrangements with Officer Apollo to get me to Hollywood VOC.
All right, that sounds good, and you know, there's also, just a suggestion, there's JC's recovery, maybe you could volunteer there, but it sounds like maybe you'll get your act together. So adjudication, time served, any and all court costs, and you can volunteer, and certainly, if you pay the money in the court costs, you can't ask for money by panhandling, okay?
And the state would request that no return, Your Honor.
And no return to the place in question. Okay, thank you.
Just air him.
Thank you, Judge. Thank you.
Myron Kalaman Mines. Good morning.
Mr. Calman's here present, Judge?
Okay, you're being charged, sir, with 1 count of alleged assault. The standard bond is $100. Is the state asking for anything? Public defender?
The state is asking, Your Honor, for a bond increase to the amount of $10,000.
Okay. You mean because of the alleged, I'll shoot you right here?
Yes, ma'am. And
can still be considered a deadly weapon, a dangerous weapon.
The pellet BB gun, which was in his possession, is still considered a dangerous weapon.
And I do find probable cause and bond is set at $10,000. Thank you.
And no victim contact, Your
And
Honor,
no
please?
victim contact.
Thank you, Your Honor.
Of course.
Judge,
Russell?
Judge, $10,000 for a second-degree misdemeanor for an assault? $10,000?
A judge will have to hear it, but that's what I'm ordering. Thank you.
Judge, that would be
Russell,
over a
moment of-
defense objection. That's
Okay,
not
it's over your objection.
corresponding
Got
to
it.
the second-degree misdemeanor charge. $10,000 presumably is tantamount to no bond. It's disproportionate to the allegations. $10,000 is in excess of the much more serious cases we've had before this court this morning.
Also, make a record. If we could possibly go sidebar, I'd like to advise the court of his, Mr. Eric Lynn on behalf of the state. Mr. Coleman Mines is only 18. He has juvenile priors involving violence.
If we're gonna, we could go sidebar
I'm
on
not-
that.
Sir, I know.
Sure.
Involving violence and weapons. I won't give any information regarding the specific offenses. If we could go sidebar, I can provide the court with the specific charges in his past.
I find, if you want, come on up.
Oh, no, you just have to hit the sidebar button, Your Honor.
Okay.
Just, and
Speaker's off, and now. I have the speakers off. Can you hear me? I press sidebar.
He may be able. Solid, because we have to, even though we're sidebar, it has to be a part of the record. It just isn't going to be broadcast over the internet. Your Honor, if I may, the issue isn't about necessarily whether it's heard there. The issue is always that we don't want these priors broadcast over the internet, which I'm looking at the computer. I don't think it is being broadcast. This is not what we're saying is not being broadcast. Sorry for the interruption. That's just yeah. Do you want to call over there? Because usually No. So you can relay the priors to Hector. So if Mr. Colin Mines disagrees with, all right. Your Honor, 2016 robbery by sudden snatching. They may be able to hear us. The issue I don't know if there's anything we can do about that. The issue is it's not being broadcast over the internet. 2016 dealing in stolen property. 2015 theft. 2015 theft. 2015 robbery with a firearm. 2015 theft. 2016 aggravated battery with a deadly weapon. And 2016 grand theft, Your Honor. We can go back on the record.
Okay.
Thank
So,
you.
as a potential danger to the community, I am finding probable cause. Bond is set at $10,000. Thank you.
Judge, respectfully, I know you haven't heard from the defense as far as his ties to the community and financial resources.
I'll listen.
I'd ask you to take that into consideration. He's 18 years old. He is working. He works for a moving company. It's not something steady as far as full-time permanent employment. It's whenever they call him, he goes and works. And whenever he goes there, he makes about $40 a day. So on an average, on a week, he's gonna be making about $80 a week. Has no money in the bank, no property. His grandmother is on a fixed income, the only person that can potentially post his bond. As it was, the $100 bond that was currently set as a standard bond would have been something probably tough for his grandma to afford, but maybe something attainable. $10,000 at this point, Judge, for his financial resources, for this particular gentleman, is out of his family's reach. I'd ask you, at the very least, to consider at least lowering the bond from $10,000 to $500. It would be 5 times more than the standard bond, but that's what the defense would be requesting, Judge.
It's in drug court before Judge Zeller.
So I'm gonna lower it to 5,000. Thank you. Russell Ahmed? Is Mr. Ahmed present? Good morning. Sir, you're being charged with alleged trespassing. There is probable cause.
Judge, Mr. Ahmed, in speaking with him, he wishes to ask the court if you would consider resolving this case today.
Hear from the state, see if we have any dangers.
He's good. He's fine.
No, Your Honor.
Okay, so that's an adjudication, time served, and any and all court costs, 4 months to pay.
And
Thank you.
no return, please, Your Honor.
And no return to the bus station in question. Counsel, are you waiting for me?
Yes, Judge, I finally found my case. Damika Davis, Your Honor, here on behalf of my client, Caudell Patterson, on Your Honor's page 31. I believe I think he's in the Broward County Main Jail. There he is, Judge.
Yeah, I just have to find in this like haystack, so.
No problem, Your Honor.
Where's the, she printed out where's the affidavit? This is the whole affidavit. And, Your Honor.
Okay, I have Mr. Caudell Patterson. I have the attorney representing him. And, sir, you're being charged with alleged lewd or lascivious act on a victim up to 16 years of age and transmitting information that's harmful to minors. I see you have an
Yes, Your Honor.
attorney and you have someone here visiting.
Yes, Judge. Just so the record is clear, his girlfriend is here, Your Honor. She's present, and she is currently pregnant. The defense also has an argument as to count 1 charge, the lewd and lascivious act. He has been booked in, Your Honor. He's being held at no bond, but this is not a punishable by life crime. Actually, Your Honor, it is a second-degree felony, and at this time, the defense would be requesting that a bond be set as to count 1.
Well, let me hear from the state. Does the mom want to tell me anything before I make any kind of probable cause findings?
This is his girlfriend, Judge. I'm sorry. Go ahead, speak in.
Are you the mom of the baby?
Good morning, Your Honor.
Good morning.
Well, I just wanted to say that Caudell is not a criminal. He's the only family I have. And for the last few months, I've been homeless. He's the only person that has been helping me in any kind of way. And without him, I feel like I have no one. Right now, I'm just lost without him, and I feel like he doesn't deserve this, Your Honor. And I just please beg you to have mercy on him because he's not a bad person. He's not a bad person, Your Honor.
And I do. Go ahead. I'm sorry. Go ahead.
This must be very difficult for you. I can certainly understand that. State?
Your Honor, can she state her name?
Yes, your name, ma'am.
My name is Danica Lewis.
Can't hear you. There's so much noise.
Sorry, my name is Danica Lewis.
Danica Lewis.
Danica Lewis. Yes.
And just for clarification, this is not the alleged victim. The alleged.
No.
Okay.
Oh, I know that.
All right. Your Honor, the state would be asking for a $25,000 bond on count one due to the fact to the victim's age and the fact that this was an ongoing relationship and what's provided in the warrant affidavit, which is the text messages between the two and the strength of the evidence.
And the warrant to arrest, you've seen?
Yes, Judge, and if I could briefly respond, my client, Your Honor, is a student at Florida Career College. He is a good kid. He has substantial ties to the community of Broward County. He does have some priors, Your Honor, but they are nothing violent, nothing sexual in nature. So I would just be asking that Your Honor not impose the the elevated bond that the state has requested. And of course, all of these facts as stated in this arrest affidavit, Your Honor, are just mere allegations. We are not at trial, but they have issued a warrant, and my client voluntarily surrendered himself yesterday, Judge. He is not a threat to the community. Nothing further, Judge.
And, Your Honor, as far as the final statement, I think one can make an argument based on the allegations that there is a certain threat posed, Your Honor.
Please
So
repeat
on
that.
count one, the bond is $20,000. On count two, the bond is $15,000. Thank you. There is probable cause for both.
Thank you, Your Honor.
The state would ask for no victim contact.
No victim
Absolutely.
Thank
contact
you.
whatsoever.
Thank you, everyone. Have a great day.
You want this back? Noel Rivera. Good morning.
Mr. Rivera's here present, Judge. Hello, Your Honor.
Hello. So it looks like there was a warrant for,
It's a driving while license suspended, but the date on it, that's what stands out to me. It's a 2010 case, Judge.
and
Judge, this being Mr. Rivera, he's 27 years old. At this time, he's going to school. He's going to Southern Tech College. Judge, considering, I know this is a capias, this is a driving. On others, the court was reluctant to resolve the case and exercise the court's discretion. But what stands out, and that's why I'm renewing my request, this is a 2010 case. I'd ask the judge at this time if you would consider resolving Mr. Rivera's case today for time served.
do you have a license?
No, ma'am, no, Your Honor.
Can you get
I
one?
use public transportation. I'm currently working on it. Yes, I can. It's more of a money issue. I'm doing voluntary community service in Seminole County right now to fix that up with them, and it's just really money issue right now. I'm currently homeless,
And that's why, at least what he is trying to do, he's trying to get his HVAC license. So then that's gonna open up opportunities in order for him to get some sort of better paying job to start dealing with some of these financial issues that he's dealing with, Judge.
Okay,
right now,
I
Right now, I'm
understand all
working
that,
at,
but now this would be a second strike, from what I see on the driving record. And if that's okay with him after speaking to counsel, we can take care of it today. You still can't drive. Yes?
I understand, Your Honor.
Because if I withhold adjudication on this, it still counts as a strike in the eyes of the Department of Motor Vehicles. You had one in 2013. This is now 2017. If you have another one within the next time, you're a habitual traffic offender. So you can't drive. I'll resolve this. The court costs are $293, and I'll give you 4 months to pay. And if you need more time, you write a letter and ask for an extension. Okay, and go. Just
I just wanna make sure he understands the consequences. If I could have a brief moment.
Still being held on those charges? All he's gonna do
Is that pending?
See, he's still being. Review the.
Judge, and speaking of Mr. Rivera, he wishes to accept the court's offer. He also just wants to ask Your Honor, I believe he did this, gave this opportunity to everyone else to allow him to do community service in lieu of the court cost.
Well, it's not in lieu, but he can do 20 hours of community service at any nonprofit organization and $50 in money that I'm not allowed to convert. Okay?
Okay.
Thank you.
You understand?
Yes, Your Honor.
4 months. And he said no contest, right? Yeah.
No lo consente.
Kavon Williams.
Mr. Kavan Williams, I've been informed, Judge, he bonded.
Okay, and I'll tell you the other one's sentence in a second, okay? It was a withhold of adjudication. We're talking about Mr. Rivera. It was a withhold of adjudication in lieu of court costs of $293. It's 25 hours community service at any nonprofit organization of his choice within 4 months plus $50. And still no driving. Okay? Vian Abedisian.
North Broward, Your Honor.
Good morning.
And Judge, I don't know if there's,
Sir, you're being charged today with alleged trespassing.
Mr. Avedsian, I'd advise you not to speak about the allegations.
That's not my name. There is no case. I'm a registered vendor with Publix.
All right, so
There
we're
is
just...
no, and the manager is my friend, and this person, I don't even know who it is. Neither does the police department
Got a second page?
in Lighthouse Point.
Okay, so here's what the story is. I don't have the authority. Here's the story. You can say not guilty and they'll have to prove these allegations against you. At this point, do we
Judge,
have any probable cause arguments?
do you have a probable cause affidavit, Your Honor?
I have an arrest form.
It's a lie. The manager's my friend. This is
That's fine, I
a
agree.
note of nobody that she's gonna get fired for this.
No, it's actually back.
So I go back to Publix longer than bitch the manager's alive. He's my friend. He's the one in charge, not her. Whoever she is, I don't even know who she is. I'm an authorized vendor with Publix. I'm on injured reserve, and my company does business with them.
Okay, can you just be quiet for 1 minute? Let me try and figure what's going on, okay? Do we have a
Yeah.
probable cause issue?
Judge, I've read there's a second page of the PC I've taken a look at. At this point, I don't have a PC argument. So, I wouldn't have any objection to that.
Well, sorry, if it's okay with the court, I think maybe transferring this to Judge Warner-Ren's division might be a good
It's
idea.
a very good idea. And ROR?
Well, no, Judge Warner-Ren's bonds
Yeah, I guess so. I lived
sure
here
that they get rid of this and so she
57
can
Okay,
assist
well,
them.
we're gonna transfer your case to another judge. And it's the judge's policy that the bond stays in place at least until you get to see her, okay? Thank you.
Judge, the only thing that I would say is from what he's told me, as he just told the court, he's lived here in Broward County for 57 years. From what he told me, January of 1960, he's retired from the U.S. government.
Well, I can speak for myself. I'm a big boy now.
All right.
I'm not being adamant.
Can I
Nobody can speak for
reduce the bond?
Your Honor, I can tell you, and I don't know if you have, I know Judge, I don't know, is it up there, the booklet that Judge Pohl put together?
It's an insult to me
Is
that
it up
I'm
at
a
the bench?
member of
There's
Congress.
actually, should be a memo that Judge Lerner actually prepared regarding the specific
Okay,
issue about this.
so then we'll follow that. Thank you. Have a great day, sir.
Judge, I asked for the ROR. I don't know. Maybe that policy is
Got
or
it.
is not. I don't know. But
No, we're not there now. It's been decided. Okay, Paul Addison.
main
Good morning.
Since you're present at main judge, this is a municipal ordinance case.
Okay.
Yeah, just, any, what you can do, and as you're going through the document,
I have no problem resolving it, but you have a problem. Where do you live?
I'm Amish, but I'm supposed to be at the hack on Monday
All right.
It took me a month to get there.
That's a good start. All right, so
Saved me a month to get there.
adjudication, stay out of trouble, don't panhandle, and court costs, you can volunteer there, plus $50 that I can't convert to community service. No contest? No contest?
No contest.
All right, have a good day.
In a minute, ask the judge.
Wilbur Gaines.
Mr. Gaines is approaching, Judge.
Good morning, sir. You're being charged today with one count of alleged grand theft auto. Bond set at $1,000. Possession of cocaine. Bond set at $1,000. Cannabis. 20 grams or less. Bond set at $100. Probation violation. Felony. No bond hold. Operating without a valid driver's license. $25. And a speeding ticket.
Judge, I have a probable cause argument as to count 2, which is the possession of cocaine.
And may I hear that?
Yes, Judge. Per the probable cause affidavit, I don't want to misspeak. Yes, Judge. Per the probable cause affidavit, he borrowed the vehicle from an acquaintance. The alleged cocaine was recovered from inside of that vehicle, though the cannabis allegedly was observed on his actual person. This cocaine was recovered from the vehicle. He allegedly made statements to the police officer.
That he denied having knowledge of the crack cocaine.
Yeah, stating that he had. I thought he made a statement as to the marijuana, but I don't see that. But I remember that he did say that he denied any knowledge of the cocaine, as it was a vehicle that was not his, as he's denied knowledge of it, as it was not an actual possession of it. I would make a probable cause argument as to count 2.
This is not mine, probable cause. State.
Your Honor, there's no explanation as to how he got the car. There's no reasonable explanation. There's no name to who the car belongs to, and the crack pipe was found in the center console next to his person.
So I find probable cause, and there's a no bond hold. So in total, there is $2,125 and a no bond hold. Probable cause on all. Thank you. Over the defense objection.
Thank you, Your Honor.
Reginald Collins.
Mr. Collins, come on up, please.
Sir, you're being charged with an alleged violation of probation felony. There's a no bond hold, and I do find probable cause. Thank you. James Kent.
Mr. Kent, your present name, Judge.
Good morning, sir. You're being charged with allegedly failing to disclose facts, and for public aid over $2,000, bond is set at $1,000. In other words, alleged welfare fraud.
Judge, in speaking to Mr. Kent, he's been residing in South Florida his whole life. He is 31 years old. He lives with his mother in Lauderhill. Him and his mother have been residing at that household for quite some time. Judge, we'd be asking you to consider releasing Mr. Kent on pretrial release pending verification from pretrial. My understanding, speaking to Mr. Kent, I want to be perfectly candid, this isn't his first arrest, but I believe from what he told me, his priors were traffic offenses, nothing violent. He doesn't believe his mother has the financial ability to post his bond, so that's why we'd be asking you to consider pretrial release pending verification.
Okay. And with all respect, this is Judge Shear's case. She set the bond, and he'll have to go before her and figure it out. Thank you. Damone Oldell, excuse me.
Mr. Oldall advised me that he has private counsel, Judge. He has Mr. Scott Skyer.
She's not present, Your Honor. Good morning.
Good morning, don't say anything. Should we reset this? Has he filed a notice of appearance?
He hasn't filed a notice of appearance. I don't have a, if council wants to, sir, go ahead.
I
I'm
can't
sorry,
hear.
Your Honor. Good morning. This case was moved to federal court on June 12th. It's been to court twice, and I've got the next court appearance scheduled for July 26th. All of this is in West Palm Beach. Yesterday I was transferred down here to answer these charges, but like I say, this has since been transferred to federal court.
Your Honor, here's the situation.
Well,
Mr.
there's a hold for the marshal's office.
Mr. O'Dahl has a federal marshal's hold. It's really up to him. If he wants to proceed this morning, he can proceed on this. If he wants to have an opportunity to call his attorney, I have no objection if we reset it for the afternoon. It's Mr. O'Dahl's call.
I'll let you call your attorney, because there's 2 no bond holds on you anyhow. So call your attorney and we'll reset it for this
And
afternoon.
who did he say his attorney?
Yeah, Mr. O'Dahl, I was gonna say, who's your attorney, sir?
Scott Skyer out of West Palm Beach.
How do you spell the last name?
Skeier.
Okay.
We can reset for this
All right,
afternoon,
we'll
Your Honor?
reset it for this afternoon. Thank you.
Thank you.
Christopher Andrews?
Mr. Andrews is here present, Judge?
Good morning, sir. You're being held on 2 no bond violation of probation felonies allegedly. Your next hearing date is on July 11th. I find probable cause. Joseph Lucas. Good morning.
Good morning.
Sir, you're being held on 3 no bond alleged violations of probation felony hold. Your next hearing is on July 11th at 8:30 in the morning, and I find probable cause on all 3. Thank you. Sadiq Wilson.
Excuse me, Judge, I didn't hear you.
Mr. Wilson.
Mr. Wilson.
Good morning. Sir,
Good morning.
you're being held on a no bond hold violation of probation felony allegedly. Court finds probable cause. Your next hearing date is July 11th at 9 a.m. Okay, Roberto Martinez. I can't hear it. There's so much paper shuffling. I'm going.
Can you,
What?
thank you.
I don't mean to be rude. It's just so loud. All right, 79. Hold on. Count 79. I'm almost there.
Judge, for procedure, Mr. Martinez did decline the services of public defender. He spoke to his wife. I believe he informed me his wife is hiring private counsel.
Okay, now tell me about 79 grand theft again. What's
It's okay, you don't have to do it. It's luckily, no. We have a nice judge. And I want you to pay close attention to that.
so it should be more than it should be less than $10,000 or more, but less than 20,000. Okay? For 79.
Correctly, 79.
Are we resetting this till he hires private counsel? What are we doing?
I mean, it's his call. It's one thing, like the last gentleman who has an attorney. I mean, we can't just put it off until his
Right,
his
we
wife
can't really
decides
put it
to hire
off till
one.
you hire an attorney, and I can reset it for this afternoon, but that's about it. Or I'll find, we can reset this for this afternoon, but we have to find out one way or the other, whether you have an attorney or you have a public defender, whether there's probable cause.
I still have to talk to my wife because I haven't gotten a hold of her at all to find out if they got the attorney or not.
So this afternoon?
That's fine.
And if I could just ask now, because I'm trying to reach Mr. Skyer, are we starting at 1 this afternoon or 1:30?
I thought 1:30, but.
We usually start at 1 on Fridays, but it's really.
Okay, then we'll start at 1.
Okay, thanks. Thank you.
Start at 1. So I'll reset this, Mr. Martinez, for this afternoon.
And
All right?
Mr. Martinez, just if you reach your wife and have the attorney, tell her to tell the attorney we're starting at 1 o'clock.
Okay,
Okay, so I'm making no determinations yet, and I'm not signing anything yet.
And Judge, the only thing that I would say, well, I'll cross that
I
for this
think we
afternoon.
should wait till we get
Yeah,
there.
that's
Thank you. Jamie Medina. Or Jaime Medina.
Judge, Mr. Medina's here, present, Judge. He's the bond service.
Can you all stop making mistakes?
Okay, and we have 2 no bond felony holds, and I know you have something to tell me.
It should only be 1 count.
Oh, there's only 1 count, no bond, so one of them is gone. Okay.
Which one?
There's 1 count, if I find probable cause. There's a no bond hold, and your next hearing is on July 11th at 8:30 a.m. Okay, thank you.
Thank you.
Richardson Belazar.
Mr. Belazar is here, present, Judge? Hi, good morning, Your Honor.
Good morning, sir.
Objection declined to serve the public defender.
Right, there's 1 count, alleged possession of cannabis, over 20 grams, $1,000, probation of violation, no bond hold, driving while license suspended, 3rd or subsequent offense, $750, and allegedly not wearing your seatbelt. I do find probable cause. Thank you.
Your Honor,
Yes.
if it please the court, if you could call a case out of turn.
A little louder, Mr.
I'm sorry, if it please the court, if we could call a case out of turn on page 33, Floyd Williams.
Williams, okay. Is that near the end, or?
Mr. Floyd Williams is here at Maine.
Hey, I have Mr. Floyd Williams. Good morning, everyone.
Good morning, Your Honor.
All right, so, officer, please
Detective
raise your
Gratz.
right hand.
Yes.
You swear and or affirm the testimony you give will be the truth and nothing but the truth.
Yes, ma'am.
Please state your name for the record.
Detective Joseph Gratz, Gratz.
Okay, thank you. Are we going to inquire? Is there anything you'd like to tell the court? State?
Detective, and Your Honor, just to advise the court, you had Mr. Williams' co-defendant just the other day.
Yesterday.
Yeah,
Jimmy Burke.
feels like other than that. Detective Gratz obviously prepared this probable cause affidavit. Detective Gratz, is there anything you'd like to advise Judge Backman and the concerns you have for the community of Hollywood?
Yes, just for the case today on the one, Mr. Williams and Mr. Burke committed a burglary on 421. They are being followed by police officers that night going from house to house. Their MO is to check vacant properties to steal the appliances out of them. During the confession, we spoke to Mr. Williams yesterday. He admitted to being a lookout on several burglaries. This has been going on countywide in multiple cities. He admitted to being involved as a lookout in several of the Wilton Manors burglaries. Their charges are still pending. They should be dropped off in the near future on that. I asked his profession. He told me he was a drug dealer. That's what he actually said. He also allowed us to go through his phone while we were questioning him. There were multiple pictures of brand new stoves, refrigerators. So he's still actively involved in these crimes where they're taking appliances out of vacant homes.
Histories, as far as Broward Priors, 2010 grand theft, 2010 tampering with evidence, 2001 possession of cocaine, 26 and a half months state prison, 2000, possession of cocaine with a VOP, 26 and a half months state prison. 1994, aggravated battery with a violation of probation, 6-year state prison. 94, burglary of a dwelling and grand theft with a VOP, just under 47 months state prison. I believe pretrial has additional priors that were outside of Broward County. Nothing outside of Broward? Okay. Your Honor, based on the information provided by Detective Gratz and Mr. Williams' criminal history, I do believe he poses a safety concern to the community, not just to the property of the community, but also based on apparently making admissions to law enforcement that he's an active drug dealer. Your Honor, I understand his history is not as severe as his co-defendant, so I won't be asking for a $75,000 bond that you set on his co-defendant's burglaries. However, I would be asking for a $30,000 bond on count 1, noting that these burglaries also involve dwellings, people's residencies. And I would also be asking for a pretrial release with a GPS monitor and no contact with his co-defendant, Timothy Burke.
Judge, in speaking to Mr. Williams, he's 40 years old. Right now, unfortunately, he's not employed. He said he's looking for work. Whenever he can, he speaks to a particular moving company, and whenever they have work for him, he makes about $80 a day. That's not anything stable or anything like that. It's whenever they call him. He lives in Fort Lauderdale. He's living with his sister. He's been residing at the location for several years now. From what he informed me, his sister doesn't make much financially, so what the state is proposing as far as a bond would be tantamount to no bond for Mr. Williams. Judge, considering I would ask you to consider his ties to community and his financial resources. Respectfully, I'd be asking you to consider setting a bond of $5,000 on count 1 and leaving the standard bond as it is for count 2 where no bond is necessary.
I'm ready to rule, and $35,000 bond on count 1, pretrial release with a GPS monitor if he posts, no return to the place in question, and no contact with the alleged co-defendant. Thank you. Dontavius Morris. Good morning, sir.
Mr. Valentin, it's your present judge. He informed us he declined the service as a public defender.
Okay, so you're Mr. Morris? Is this Mr. Morris?
Yes, ma'am.
Good morning. So, you're here on 2 alleged no bond holds for a capious felony set by your judge and a capious misdemeanor count 3, bond set at $500. I do find probable cause, and your next date is July 21st at 10 a.m. Thank you.
I have an assertion.
No, Luis Granados.
I got a bond.
Luis Granados.
Judge, I've been informed Mr. Granados is in regular court this morning.
Okay, so we reset this
Yes, Judge.
for this afternoon.
I don't know if he'll be brought back by the start of 1, so I'm being informed by the deputies for tomorrow.
Okay, so reset for tomorrow. Paul Douglas.
Mr. Douglas, come on up, please. Page 29.
Good morning.
Good morning.
So you're being charged with a total of 11 counts. So I'm going to read them to you. The first one is possession of cocaine, bond set at $1,000. The second one is possession of cannabis, 20 grams or less, $100. 2 charges of possession with intent to sell oxycodone for $2,500 apiece, and a third possession with intent to sell or deliver Vicodin, $2,500, and possession of Xanax, $1,000. Drug paraphernalia use or possession, 100. Count 8, resisting without violence, $100. Count 9, tampering with evidence, $1,000. Count 11, driving while license suspended, $100. And allegedly not stopping at a stop sign. And the court does find probable cause on all of these counts.
Judge, I've got probable cause arguments on counts 3, 4, 5, and 9.
All right, I'll hear them.
Counts 3 and 4 are the same charge, possession with intent to sell, manufacture, deliver oxycodone. First off, Your Honor, I would say as a catch-all that I don't believe the allegations as contained within the probable cause affidavit would warrant multiple charges for the exact same crime. Second off, Judge, as it pertains to the possession with intent aspect, it's going to be the same argument that I'm going to make as to count 5. I don't believe that the allegations as alleged warrant the possession with intent aspect. As to the oxycodone, all that it shows is that there's a baggie that contains 5 pills and 2 pills. I'm not sure what the possession with intent is on that. As to the hydrocodone, from what I'm reading, it appears that it's all within a small clear plastic bag containing 8 pills. So it looks like it's the same thing as to the hydromorphone and the hydrocodone. The simple presence of the alleged narcotics inside of a bag alone is in no way indication of possession with intent to sell, manufacture, or deliver. The fact that they're simply located inside of a bag. So that's my PC argument as to 3, 4, and 5. Again, going back to 3 and 4 being the same charge. Not sure how he could have 2 charges for the same drug on the same crime. As to count 9, the tampering with evidence, Judge, I don't believe that there's a sufficient showing of the tampering of evidence within the allegations. All that it shows is that as he is driving his vehicle, he allegedly threw some baggies out the window. Those baggies were promptly recovered by the police officers. And also, as he is entering the residence, he dropped a pill bottle. Again, immediately recovered by the police officers. I'm not sure that those actions rise to the level of tampering or fabricating physical evidence that would warrant the additional felony charge that's in count 9. So, Judge, I've got those probable cause arguments as to counts 3, 4, 5, and 9.
And they're duly noted, State?
We're fine with the simple possession. However, as to
What count?
on 3, I believe it was 3, 4, and 5. So without the intent to sell.
So we'll stipulate to probable cause as to possession only?
And as far as the different type of oxycodone, they're listed as one is a 30 milligram pill, and the other is a 15 milligram pill.
But they can,
So technically, they are different.
they can charge in the alternative or arrest or charge in the alternative.
So what is the bond as to possession only for 3, 4, and 5?
Judge, if I could respond, I don't know if the state's
Hear what
done.
they have to say first.
Sure.
$1,000 for possession.
And the tampering is the woman trying to discard the pill bottle while writing
And an argument for the tampering would be, Your Honor, is that he was trying to discard the evidence,
the pill bottle.
the pill bottle. It says in the PC as he ran, he discarded of a pill bottle containing 1 hydromorphine.
Judge, if I could respond as to the dual charges on 3 and 4. Your Honor, based upon the reading of the probable cause affidavit, both the 5 30 milligram pills and the 2 15 milligram pills are recovered from the same baggie. And I don't believe the potency of the alleged substance warrants different charges. I don't believe that these could possibly be filed as 2 separate crimes. It would be one crime, which would be a possession or if the state chooses to pursue possession with intent of oxycodone. They're recovered from the same object. So I believe that there could be a probable cause finding as to one count, but not to two counts.
Well, I'm ready. Anything else, State?
Your Honor.
As to count one, bond is $1,000, probable cause. 2, probable cause. 3, 4, and 5, probable cause as to possession only, $1,000 each. The Xanax, as I said, $1,000, probable cause. 7, 8 are probable cause, $100 apiece. 9, tampering, $1,000 over the defense objection. 10, driving while license suspended. First offense, $100. Thank you.
Judge, I know my colleague, the argument was back and forth regarding probable cause. As far as Mr. Douglas's ties to the community, regarding the monetary bond that is currently now being set by the court, Judge, in speaking to Mr. Douglas, he's been residing in our community his whole life. He's 53 years old. He's disabled. He gets $715 per month. He lives in Dania with his mother. Been residing there his whole entire life. His mother was working her whole entire life. She's a retired mental health nurse. She's on a fixed income. Considering, Judge, he has a strong ties to the community. He's been here his whole life, and right now he's on disability, so he doesn't have much financial resources. Judge, I would ask, I know you found probable cause for simple possession. What we have before you is potentially a gentleman who's having maybe some sort of addiction problem. I would suggest, Judge, is would you consider pretrial with some sort of component with random drug testing, so then therefore he could be on the outside helping his mother out, taking care of his mom, and at the same time, the court would have assurances because he would be tested. If he goes ahead and tests positive, a warrant would be submitted for him, and he'd be right back in here. So respectfully, Judge, considering these are possession cases, his strong ties to community, I'd be asking you to consider pretrial release pending verification.
Mr. Douglas, frankly, should be held right now under Florida Statute 94806 for violation of probation. He was placed on 5 years probation on June 30th by Judge McCarthy for possession of cocaine, possession of alprazolam, possession of morphine, and possession of oxycodone.
So respectfully, I'm denying your motion, and everything will stay as previously ordered. Okay, John Foster. John Foster?
I've been informed Mr. Foster bonded, Judge.
All right, then there's probable cause. Antonio Grant.
North Broward, Your Honor.
Good morning, Mr. Grant. You're being charged with one count of possession of a weapon or ammunition by a convicted felon, Florida felon, and tampering with physical evidence. The court finds probable cause on both counts, and what are we setting the bond at, if any?
The court would suggest the state would suggest 3,500.
Judge, if I could be heard.
What did you suggest?
3,500.
Okay, and sir?
Your Honor, I spoke to Mr. Grant earlier. From what he's told me, he's lived in Fort Lauderdale all of his life. He resides with his wife and his sister. He's got 4 children and a grandchild as well. He is working himself, doing kind of side jobs. It sounds like his wife is working at Winn-Dixie. Judge, he's been a member of the Vision of Christ Church in Pompano for 10 years. Based upon my understanding of his finances, they appear to be very limited. I would ask the court for the lowest bond appropriate.
Well, based on the probable cause affidavit and my finding of probable cause, count 1 is 3,500 and count 2 is 1,000. Thank you.
And the state would request a no victim contact.
And no victim contact. Thank you. Brian Hodgson.
Hodgson is here present, Judge of Maine.
Good morning, sir.
Good morning.
Sir, you're being held on 2 alleged violations of felony probation. Bond is standardly set at $1,000 apiece. I do find probable cause, and your next hearing is on July 11th at 8:30 a.m. Thank you. Hervin Vilson.
10 feet away.
Good morning. Sir, you're being charged with alleged. You're being charged with alleged grand theft auto. Your bond is set at $1,000, and I do find probable cause. Thank you.
To be heard and speaking, Mr. Wilson. He's been residing here his whole life. He's 28 years old. He is a disabled veteran. He gets in benefits about $263. He served our country in the United States Army from 2005 to 2013. He lives in Pembroke Pines with his wife. They've been married for 8 years now. His wife is a school teacher. Unfortunately, she just got laid off at the end of this school year. Judge, he's a registered voter here in Broward County. Considering his strong ties to the community, Judge, unfortunately, because of his disability and his wife being laid off, there isn't much financial resource in order to post his monetary bond. Judge, and considering this is a nonviolent offense, I'd ask you to consider a pretrial release on behalf of Mr. Wilson.
If I may have one moment to look up his priors.
Possibly the Veterans Court subsequent to all this.
Can we allow Veterans Court recommendation? No. State's recommendation would be for the bond, which is already set in place, the $1,000.
Priors?
There are, but they're traffic priors, and he has a failure to appear. Bench warrant was issued out of Miami-Dade back in 2015 for a DWS.
What date?
Do you have that as opened? Yes, I have it as open as well.
Okay, so I'll set bond at $7,000.
$7,000?
I'm sorry, I meant 700. My bad. Sorry.
700.
Thank you. Darrell Walters. Good morning.
Mr. Walters is here.
Sir, you're being held on 4 court orders with no bond. Set 5 and 6 are a missile into a dwelling, and we have to determine for both of them the bond. I do find probable cause.
Judge, I see the no bond holds on counts 1 through 4 on the case number 16-14566 EF10A without any other information except for the fact that there's a capias. As to counts 5 and 6, I do say as well, hold for magistrate. I don't have any information as to those 2 counts. I don't know if that's a capias.
See information. We have in our paperwork a copy of the PC attached. I don't know if Your Honor does at the very end.
Filed on.
Can I have a moment to review?
Sure.
Court ordered held on. Counts 1 through 4. Same picture. pedestrians, the victim in counts 1 through 4 also. This offense violated his release conditions. That's why, as you can see, there's a motion to revoke here, order to revoke. For the bond, 2 counts of deadly missile, that's, so that's accurate.
Okay, Judge, I've had the opportunity to review. I'm ready if the court is. Judge, as to counts 5 and 6, first off, Your Honor, I don't see how there could be 2 counts as to throwing a missile into a dwelling, vehicle, building, or aircraft as it appears, if anything, there'd be 1 criminal act. Second off, Your Honor, from what I can see, there's absolutely no evidence that Mr. Walters allegedly threw anything into this vehicle. There's a statement that he had a beer bottle, and then the statement that he no longer had a beer bottle, and that in between the windshield was smashed. There's no allegations that the beer bottle was the object that was thrown or not thrown. There's no allegations that anybody observed him throw this object or any other object. There's nobody inside of the vehicle who's saying, we saw such and such object strike the vehicle. Additionally, Your Honor, it doesn't appear that anything went inside of the vehicle. I don't have the statute up in front of me, but if anything, there would be something that struck the vehicle. So on those many arguments, Your Honor, I don't believe probable cause can be shown as to 2 counts of throwing a missile into a dwelling, vehicle, building, or aircraft.
Okay, thank you.
Regard, Your Honor, to the 2 charges, there's 2 victims. One of the victims is the same victim on counts 1 through 4. Additionally, this case, it was charged, it was filed.
Okay,
It was not
and
unfiled.
This case has been filed?
It's been filed, correct? One moment. This case has been filed? Yes, it has been.
okay, so I'm ready to rule on the 4 corners of the probable cause affidavit, and I do find probable cause for 5 and 6 as well, and the amount to be determined.
Before you determine the amount, if I could have an opportunity to address the court as far as Mr. Walters' ties.
Of course.
He's 20 years old. I know he's being held no bond on counts 1 through 4, but considering he's currently working, he works at a cleaning company called Campus Solutions. He's been there working for about 6 months, making $9 an hour. He lives in Pompano with his godmother. He pays his portion of the rent, which is $400 a month. He has no money in bank, no property. Judge, considering as far as, I know Your Honor found probable cause, I'd ask you for mitigation purposes to take into account my colleague's argument that it's not the strongest case before you. However, I do realize you found probable cause. Respectfully, then we'd be asking you to set a bond of $1,000 on count 5, $1,000 on count 6.
State?
One moment, Your Honor, the state is looking up his priors. The state would argue that this defendant is a danger to the mother and victim in this case via the pending domestic violence charges 1 through 4 that clearly isn't staying away from her. The state would ask for a $5,000 bond on each count.
Anything else? $10,000 on each count. $10,000 on 5, $10,000 on 6. Thank you. And no victim contacts.
Thank you.
Ernest Mobley.
Judge, I just got a call from North Broward. He's a medical reset.
Thank you very much. Louis Bruni.
Back to Maine.
Mr. Bruni.
Judge, I've been informed by the deputy's confinement status took him off the docket.
He's removed. Schneider, Valson.
Mr. Valson, come on up, please.
Good morning, sir. You're being charged with allegedly burglary of an unoccupied conveyance unarmed.
Judge, I have argument as to PC on this one.
All right, please be heard.
Your Honor, there's no allegations that Mr. Valson entered or remained within an unoccupied conveyance, which is an element to burglary.
There is also a pretrial services revocation order that I'm considering. Okay, thank you.
And what does it say? Yeah, Your Honor?
Yes.
The state would ask, and I would point out, the allegations seem to be more rise to an attempt. The officer actually wrote in the very first sentence, felony attempted burglary conveyance. They're unable to book someone for attempted burglary because they can only put one statute number in the data entry, and there is no statute for attempted burglary. So, but we would ask the court to find PC for attempted burglary.
PC for attempted burglary.
There's witnesses and allegations he was going up to cars, pulling on car handles. I think that certainly gives enough for probable cause that there was an attempt, that he attempted to commit a burglary and what his intent was.
And what is the alleged bond?
See that on?
He's
What?
got-
One
he's-
moment.
He has a resisting without violence and bar 2017 failed. He won. States will request $2,500 bonds.
Okay, now, pretrial, are you still, is pretrial still asking that I revoke the order based on battery or attempted battery?
Judge, we didn't hear you.
I'm asking pretrial because they want me to revoke pretrial services based on battery, disorderly conduct, and criminal mischief.
Probation for something.
I can't hear. Okay, just asking. We have to fix it.
Judge, I know Your Honor found probable cause for attempted burglary. And speaking with Mr. Valson, he's adamantly disputing the allegations. I informed Mr. Valson he will have his day in court, and that's something that he's looking forward to. As far as regarding the bond amount on this particular case, Judge, I'd ask you to take into account, he's been residing in our community for 38 years, he's 40 years old. He's looking for work. He was previously employed doing construction, making about $10 an hour. He lives in Fort Lauderdale with his sister. He's been residing at the same location for the past 5 years. His sister is the only person that could potentially post his bond. So I'd ask you to consider something reasonable pertaining to Mr. Valson as far as a monetary bond on count 1. As far as the open case in which he's currently out on pretrial, Judge, by revoking pretrial and potentially holding him no bond, that would be the most severe sanction this court can impose. I'd ask you to look into less restrictive means to ensure the safety of the community. Either one, to impose a stricter form of supervision by pretrial, such as a heightened level, or 2, in the alternative, if Your Honor doesn't feel comfortable anymore with imposing pretrial, I'd ask you in lieu of pretrial then to impose a monetary bond on the case that he's currently out on, and that's what the defense would be asking or requesting, Judge.
All right, response state. Let's do one thing at a time. For the PC for attempted burglary, I'm going to find or hold bond at $2,500. I do find probable cause. And let's discuss the pretrial services revocation order now.
Probable cause as to the attempted burglary, Your Honor?
Attempted, yes.
Thank you.
Pardon?
I can't make a recommendation on that case, it's a municipal ordinance.
Judge, and that's why I'm asking you at this time to not revoke his pretrial.
Well, I don't know how Mr. Romero can make that request, it's a municipal ordinance case.
Okay, so I'm just going to decline, okay? So I'm declining revocation.
Thank you, Your Honor.
I appreciate it. Perfect, thank you.
Michael Negro? Good morning.
Judge, I'm sorry, before we proceed with Mr. Negro, I believe I'm missing a second page of his PC unless everybody only has the same single page. So if I could have a moment to straighten that out with the state judge?
Yes, there seems to be 3 pages. So while we're doing that, we're just going to do a brief recess. On the record at the main jail, and we need Michael Negro. Good morning again.
Thank you, Judge. I've had the opportunity to review the probable cause affidavit for Mr. Negro. At this time, I don't have an argument as to probable cause.
Probable cause is shown. Does the state have any arguments as to raising, decreasing?
No argument, Your Honor. We believe the
Alright.
bonds in place are
So
appropriate.
the bonds, there is probable cause on possession of amphetamine, bond is $1,000. Possession of oxycodone, $1,000. Alleged cannabis, $100. Drug paraphernalia, $100. And an expired tag traffic ticket.
And Judge, just for the record, the defense would have no objection as far as the standard bond. Mr. Negro is going to post his bond.
Okay, very good. Thank you. Michael Marrero. Good morning.
Mr. Moreno is here present, Judge. He did inform me
Hello.
that private counsel, Mr. Johnny Weeks.
This is Aaron Passy. How you doing? I'm sitting next to Aaron. I just wanted to make you aware that
Okay, but Mr. Weeks is not
Antonio
here.
Grant,
Has he filed a notice of
I made a
appearance? or-
mistake, and
What?
his bond was set at $3,500.
What's that you added?
And I
It's
just
so
wanted
loud
to make
in
you
here.
aware that we didn't put on the record, making you aware that.
Another touch strike?
I don't know if we're gonna reset him, Your Honor, or not.
What do you want to do, State? He says he has Johnny Weeks as his attorney.
Yeah, I mean,
Probably overthought it.
obviously,
And
we
then
can
I saw
reset it for the
Greg
afternoon if
Top
he wants to reach
next to
out.
the
I mean, I
victim's
can
name
try to
deceased.
reach out to Mr. Weeks.
Reset it. Try to get in touch with your attorney 1 o'clock this afternoon, okay? Thank you.
I mean, do we know, has he
I
retained
can ask
Mr.
Eric, but I
Weeks?
already did ask him. and he
Well, I guess we'll deal with it
kinda
at 1
gave me
o'clock.
like
Yeah, they want another charge, touch or strike battery, number 5.
Give me 1 second.
So I just wrote that down, but I haven't determined probable cause yet. Okay, Arthur Kennedy.
I've been informed Mr. Kennedy bonded, Judge.
He said yes. Okay, 1 second.
Eric Christie.
Mr. Christie's here present, Judge Jermaine.
Good morning, sir. Long morning. Thanks for your patience. You're being held on 1 capious felony and a second alleged capious misdemeanor, both of which have no bond holds. And I find probable cause.
Count two is a $1,000 bond.
Oh, you're right. It's, yes. So it's $1,000. Thank you. Yes. I find probable cause.
Nothing on this case, just before we move on to the next case. Your Honor, we have a case we already dealt with this morning, Antonio Grant. I'm not gonna go into the case at all since he's not here. I have spoken with the, after we handled the case, the detective that wrote the PC affidavit and obtained the information we weren't aware of, information we would have provided to the court if we were aware of, so the court wouldn't have been aware of it when sending the bond. All we're asking is if we could have him brought back this afternoon. It's 10:39 now. If we deal with the case at 1:39, that'll be 3 hours from now. The detective's gonna be coming in. So, Your Honor, I would just ask, if the paperwork could be, collected again, so we won't be able to post bond.
This is not Mr. Christie's case,
No,
Mr. Romero.
this is, Antonio Grant. It's
You're good.
BSO case, possession of firearm by convicted felon.
Okay. So whatever, yeah.
Antonio Grant.
We're bringing
We're
him
bringing
back
back
at
in the afternoon.
1:30.
And I guess, so, Your Honor, if you could order verbally to have the bond set back in, no bond hold for magistrates.
No bond hold until magistrate at 1:30.
I'm sorry, what page was he on? What page was he on, Mr. Grant?
It's not in the old courthouse, it's at the new courthouse.
4155.
4155.
Page 30.
On the floor.
Thank you.
Thank you. All right, bye.
Correct. Thank you. Okay, so can we move forward? Are we ready?
Ready to proceed, Your Honor.
Okay. Dale Bonick Devon.
Main jail.
Mr. Jail, Bonnie Clavon is here present, Judge Jermaine.
Good morning, sir.
Morning, ma'am.
You're being charged with alleged possession of cannabis, less than 20 grams or less, introducing contraband into detention facility, bond set at $1,000, and a capious misdemeanor, bond set at $500. Do we have any probable cause objections?
I don't, Your Honor.
Okay, so I find probable cause on all three, and the possession of cannabis, isn't that supposed to have $100 bond?
No.
Up to you, Judge.
Oh,
No,
okay,
yeah.
thank you. So 1,500 in total. Your next hearing, sir, is gonna be set in division. Thank you.
Judge, excuse me, I should say that obviously the court has the discretion to set a bond, but there's not necessarily a bond on that
All
case.
right, thanks. Cartwright Joseph?
Yes.
Mr. Joseph is here present, Judge.
Yes, no charge. Good morning. Sir, you're being charged as a career offender, failing to register or provide information. There is a no bond hold, and I do find probable cause.
Is this a no? No, this is.
Inquire as to why it's no bond.
It should, that's a mistake. It should be hold for magistrates. It's a not in custody.
Okay.
That's a not in custody capias?
Yes, he's entitled to a bond, Your Honor. We would just ask,
Judge Siegel just
If
wrote,
we-
oh yeah,
well, no, if we could just have a
no
moment to
bond
look up.
jail, hold for magistrate hearing.
If we could
That's
just
what-
have a, yeah. We're just gonna need a moment to look up his.
Okay.
I would sort of, if you can't, by social, because you can't. See, but he's got aliases. See, that's the problem with that system.
What's the BCCN?
Hold on, I already checked that.
NCCIS?
I'll give you, yeah, I'll give you his social security number.
Does that mean I take the name out of the box and just do social security?
No, include that also. Five.
Yes.
Escape, resisting without violence with a violation of probation, 20 and a half months state prison. I suspect there may be additional priors, but I don't have any in front of me. Your Honor, we're going to be asking for a. It's, this goes back to 2015. Obviously, it's taken law enforcement this amount of time to locate Mr. Joseph. Having located him in Martin County and bringing him here from Martin County.
Judge, we can't hear the state.
The state would be asking for a $7,500 bond, but to assure his future appearance in court, the state would also be requesting pretrial release with the GPS monitoring.
Judge, strictly as to PC, I guess before we proceed to his ties to the community, obviously the court can't consider the speculation that there may be priors. I mean, we have what we have. As to the fact that he hasn't, this is a 2015 case, we've got no statements as to what efforts law enforcement conducted to try to locate Mr. Joseph. So the intimation that Mr. Joseph was evading service, I believe, is inappropriate. Mr. Romero?
That is correct, Judge. My understanding, Judge, employed. He works at Red Carpet Delivery. I don't want to get too much into the facts. He's very much disputing this. He checks in on a regular basis. As you can see, this allegation stems from 2015. So since then, he's been regularly checking in. So there's obviously some alarms or some concerns in my mind as to some potential mix-up. But I know that today's not the appropriate time. You'll have this day in court in order to dispute that and present the proper paperwork to the prosecutor. Hopefully this then case will be no info. But I know we're here to set a bond at this time. Judge, he's currently, like I said, he's working at the Red Carpet Delivery company. He's been working there for about 3 years now, making $8 an hour. He's been living in Fort Lauderdale with his mother his whole entire life. His portion of the rent is approximately $500 per month. Judge, right now, I'd ask you, considering the circumstances of this case, I'd ask you to impose a $1,000 bond on Mr. Joseph's behalf, and also I'd ask you to sign a phone order allowing him access to his phone in order so he could potentially maybe call some friends to help in the endeavor of posting his monetary bond. Judge.
Your Honor, the issue is, very briefly, one, he has aliases. Joseph Michelet, I can tell you that, let's see, he went to prison under the name Michelet Joseph. He's used the name Cartwright Joseph. These allegations in and of themselves are the basis for the concern about his future appearance in court. Noting also, and yes, it was in '99, but it's still for the court's consideration, that he has gone to state prison for escape.
So you.
Oh, and Your Honor, and I can explain now. The reason he's being considered as a career offender, and I didn't see this originally, his burglary dwelling from 2002, he was sentenced to 15 years in state prison.
Okay, I have a question.
Yes, ma'am.
You had suggested PTR with a GPS monitor.
Yes.
And how much did you ask for?
$7,500.
So, anything else from the defense?
Judge, I know the pretrial with the monitors to ensure the state knows where Mr. Joseph's at the entire time. I believe that would assure or alleviate any concerns of the court. Therefore, in respect to the monetary bond, that's why I'd be requesting then the $1,000 bond so Mr. Joseph could potentially bond out.
And Judge, as to the defense request to have access to his cell phone?
He can have access to his cell phone, and based upon everything that I'm hearing, it'll be $6,000, the bond.
Thank you, Judge. We've prepared an order regarding the cell
PTR
phone.
with GPS monitor and access to phone. Okay? Thank you. James Hickman?
Judge, my notes say that this was a medical reset. I don't know if...
Yeah.
I don't know if he's still on loan or not. I can check.
And Judge,
And I
as to
also-
the next person, Mr. Octave, I received a phone call from Conti that Mr. Octave is out to court, so he won't be present at magistrates this morning.
Well, let me first check on Mr. Hickman. Your Honor, I'm showing Mr. Hickman is still a medical reset. And as far as Mr. Octave, Your Honor, this is a change of charge from originally it was ag assault with a deadly weapon. We filed it as a ag assault firearm. The original bond was $5,000 and no victim contact. I was just going to ask the court to place the $5,000 back on. Obviously, if he's before his judge on this case and that judge modifies it, that would supersede, obviously, anything from this court.
So any objections?
Judge, I mean, I would object to conducting a proceeding without him present, unfortunately.
So do you want to reset this
But here's the issue. I imagine, and I'll check, but I imagine he's being arraigned right now by his judge. So we're going to bring him back to first appearance after he's been arraigned by his judge, to where this court will no longer have jurisdiction over anything over him, anyways.
Do we see what court he was in front of this morning?
I'm
I have the
checking that
case
right
number.
now. Oh, also noting, Your Honor, Mr. Octave, let's see. He's also being held no bond on 2 other felony cases that were revoked when he was originally arrested on this case. He's got a calendar call before Judge Rothschild on his 2 other felony cases this morning. I mean, if counsel insists, then I have no, guess so.
Anything else?